Hello, my name is Dan Dodds. I'm the principal attorney at the Dodds Law firm in Suprise, Arizona. You know, one of the frequent questions that people pose to me is, well, is there some requirement I have to meet in order to file for divorce in Arizona because I'm from Florida? And the answer is yes. What are those criteria? Well, they're pretty straightforward. One is that at the time you bring the action, in other words, you're filing the petition for the dissolution of your marriage, you must have been domiciled in the state of Arizona for more than 90 days. Now, what's domicile mean? Well, there's a difference between someone who's here for 90 days that, for instance, comes down from Canada. Maybe they live in Quebec and they spend 100 days down here. Could they file for divorce? No, because their domicile, what they call home, is in Canada. Contrast that with someone who moves from Missouri. I've been here from Missouri. I've been here 90 days prior to me filing the petition of dissolution. Okay. How do I prove that that's true? Well, the court would look at, have you done the things that a reasonably prudent person would do who intended to move permanently to the state of Arizona? Well, what would a reasonably prudent person have done? Well, they bought a home. I can prove I bought a home. I leased an apartment for a year. Here's the lease. I opened up utilities for my phone, my Cox bill, my electricity and water. I could show that I had done those things. I'm most likely, if I intend to be a resident, I've walked down and I've got an Arizona driver's license. I've traded in my Florida license plates and I'm driving on Arizona plates so an officer doesn't pull me over and say, "What are you doing here?" So you look at the behavior of the parties, and if they have documentation to prove that they've lived here 90 days prior to the day they file the petition with the court and then serve it on the respondent, you've met that criteria. Now there's another example, much like the Canadian, why they couldn't file is, well, what about if you're in the United States Air Force and you're out here at Luke Air Force Base, and I'm from Florida? And I never intend to stay in Arizona. I'm just stationed here for a couple years. Well, if you're in the military and you've been stationed here and you've lived here more than 90 days, that's an exception to the domicile. You have met your domicile, but the criteria is different. So you could divorce your husband or wife who lives in Florida, where you came from, where you intend to return after you get out of the Air Force. You could initiate a divorce in Arizona as long as you can demonstrate, and you could get that from a commanding officer or a number of sources. When did you report for duty? And has 90 days elapsed before you filed with the court your petition for dissolution and served it on your spouse, who apparently may still be living in Florida? You would be fine. There's a second criteria. The petitioner must assert in the petition for dissolution that in their personal opinion that this marriage is irretrievably broken. Well, what does that mean? Well, that means that in my judgment, it's over. No amount of conciliation, no amount of counseling, no amount of mediation is going to get me and my wife back together, or me and my husband back together. So you must have domicile and be able to establish that you had domicile prior to 90 days before you serve your petition. You must allege that the marriage is irretrievably broken, and then the court, thusly, would have jurisdiction. Jurisdiction means that our courts have legal authority to divorce you too. And without jurisdiction, they can't do anything. So those are the two factors that will trip you up. If you haven't can't meet them, the court will kick it back to you and say sorry. If there's any other information I can help you understand about those two criteria, feel free to give my office a call. Be glad to meet with you and answer any questions you might have. Have a great day.